let's see. Well, I wanted to talk about filed versus furnished. I got some attempted. So some of you took this very seriously, this extra credit challenge. None of you were as good as our very own Professor Jack Coffey, who remembers a time when filed meant something different from furnished. So I don't take that too personally. It's just hard to compete with someone who's been doing this 50 years. So Jack sent me a reference, which I will show you shortly whenever our video comes on, and we can talk about what filed versus furnished actually meant historically. Some of you pointed out that filed versus furnished actually has an implication today, which is true, for Section 18 liability, but we haven't gotten to Section 18 liability. In fact, we haven't gotten to liability at all. So that really wasn't the question, although it's interesting, and we'll get there. You can call something not filed, and that has an implication for liability. But I was more curious if anyone could find or had found sort of what it actually meant to be filed or furnished historically, like what do those terms mean? And as soon as we have video, I'll show you some old documents. So coming back to that shortly. Another point that a few of you emailed me about last night was the Wall Street Journal article from yesterday on Reg A+. How many of you saw that? Yeah? So this is interesting, right? So the Wall Street Journal is writing about IPOs, about a new opportunity under the Jobs Act to do an IPO without triggering all of the requirements under the 1933 Act and 1934 Act. We're going to talk in maybe 3 weeks or so about exemptions to Section 5 and about the Jobs Act in particular and what the Jobs Act made available to smaller companies like those who are the subject of the Wall Street Journal article. In particular, you'll remember if you saw this article, and if not, I'll just bring you up to speed, the Jobs Act provided for an alternative path to raise capital, something short of a full IPO, under a regulation, Reg A+. Are we good? Are we live?
So it's transmitting a signal.
Transmitting? He's going to bring, okay. And Reg A+ allows you to raise up to $50 million. We're going to go through the requirements for a Reg A+ offering and distinguish it from a Reg D offering when we get there. But in the meantime, what I thought was interesting actually about the article and why I was glad some of you found it is that it gives you a chance to apply the economic framework that we've been discussing. So you could almost imagine a hypothetical question, either if you were working at the SEC trying to evaluate whether it might be a good idea to craft a regulation like this, or if you were answering an exam question where you were trying to evaluate whether or not a regulation like Reg A+ makes sense. What would be those of you who've read the article, or even if you haven't, and you just have an intuition. So what Reg A+ does is make it easier. We don't have to worry exactly how it makes it easier, but it makes it easier and quicker for you to file for an IPO if you cap your offering at $50 million. What the article pointed out is that the vast majority of firms who are using Reg A+ are, in fact, trading at a price today lower, substantially lower in many cases, than their offering price. And so I'd be curious, if you think back to our conversation around IPOs, can someone give me a story why it is that we might be seeing firms who are using Reg A+ trading at less than their offering price, and what the economic implications, why we might be seeing that, and what does that have to say about whether Reg A+ is a good or bad thing? Who has an idea about this story and would like to share? Anyone? Anyone? So Reg A plus, yes. I think I have you already. Let me open up my student chart here. Not Patrick, Joseph. Yes.
My mic doesn't work.
Your mic doesn't work. That's okay. AV does not work in this room. It partially works. Yes.
Caveat is I haven't read the article, but from the description you just gave, it sounds like it's possible that because they're filing faster, people haven't had as much time to gather information, so they can't be as confident that it's worth the offering price, so it trades for lower.
So that's right. So it could be, so Joseph says, look, it could be that they're trading for less than the offering price because there's less time to learn about the offering. I think you're thinking about Section 5, but remember that Section 5 is prior to the IPO, the registration statement becoming effective, right? So it could be that there's less, certainly probably is less time to process information about these filings, but that would apply prior to the IPO point. Here we're seeing prices for these firms lower than the IPO offering price, so this is later in time, right? So why is it that later in time we might be seeing what we're seeing with A-plus offerings, that is, price is lower? Yes, I'm pretty sure I have you as well. Carly, yes.
Sorry, my mic doesn't work.
Yes.
It might indicate that we do need the waiting period because the offering could have been made at like a volatile time, and it could have been made at like a high point in that cycle that the waiting period is designed to kind of wait.
Nice. So Carly says it could be that that's exactly why we need the waiting period. These offerings, very good, very good. There's actually quite a bit of insight in what Carly said. Really, really deep answer. Very good one. Let me try to unpack why it's such a good answer. So Carly points out that the quiet period is designed to mitigate the risk of overpayment. That is, it's designed to avoid Arvida-type situations where you are finding out about an offering and signing up for it, an investment opportunity, too soon. Still not online. Okay, keep going. Just you can do this the whole class, no big deal. It's an exercise in concentration. So Carly says, look, so can you go back to Arvida, right? So Arvida, the concern that's motivating the quiet period, and we see this in Arvida, is that we don't want people signing on to investments, putting their cash at risk, when in fact they don't have enough time to think deliberately about the sort of investment that they're making. In other words, we're trying to prevent this enthusiastic rush, like we saw in Arvida, where the court point out where you put all of these really cool facts out to investors. They get all excited. They put their money in. Why do they rush to put their money in? Remember our conversation yesterday that waiting is never a good idea, right, in a free market, because if there is an opportunity, it's probably gone by the time you've waited. Okay? Not sure as if this makes sense. So in Arvida, the concern is, look, we need the quiet period because otherwise natural market incentives are such that you're going to rush and buy early. So the quiet period slows you down. And so one point that Carly's making is that the acceleration that the Jobs Act provides, or that Reg A Plus provides, cuts out that opportunity. And unlike WIXIS, okay, we don't have market attention on these companies. These are IPOs. In fact, they're not just any IPO. They're an IPO of a small company that is largely untested and not well known to the market. So we would think it's very likely that we would get the price wrong. In fact, we think it's likely that well, let me say this differently. We think it's likely that we'll get the price wrong, that we'll be overly enthusiastic, but there's another part of Carly's answer that's really, I think, really makes it an A answer, which is that it's not just that we'll get the price wrong, right? Now, because if we get the price wrong by cutting short the quiet period, then we should be just as likely to get it wrong in both directions. This is the intuition that I want you to be developing, okay, which is that we should be just as likely, if all that's happening by cutting short the quiet period is that we're missing out on some bad investment opportunities, we're saving ourselves from investing in poor investment opportunities, it should be just as likely that we're also going to miss some great investment opportunities. And so then what you should expect is that Reg A+ offerings might be overpriced some of the time, underpriced some of the time, and thus, on average, the offering price on average should be pretty similar to where the stock price trades down the road. Nod your heads if you see this. Now, but Carly says something really nice, and see how you can get this intuition even in a very short answer, which is that maybe what's happening is that we're cutting short the quiet period at a time in a sort of macroeconomic sense where there's greater optimism, right? Where there's something about the cyclicality of the economy that causes us to systematically overestimate the value of firms rather than underestimate. And that sort of systematic bias, if you will, that tendency to be excessively optimistic at a particular point in time, is the only kind of mistake that can explain that 90% or whatever the figure was in the article of A+ IPOs are overvalued. Now that's a little abstract, so you have to kind of think, if you were writing an answer, you'd want to try and unpack it a little bit more. What is it exactly about this time? So Carly, do you have an idea? Can you expound on that a little bit more? What is it about a particular point in time, like maybe the one that the article's talking about, that would cause the pricing mistakes to be in one direction and not the other?
So I didn't read the article, but I guess if the market was over optimistic maybe generally, or if I don't know, I guess it would be possible if there was like a reduction in the number of like normal IPOs that were occurring, and then this Reg A+ came out, and so suddenly there were companies that were taking advantage of that, and there were less normal IPOs to put capital into, then there would just be less things you could put money into, and so they might be more likely to invest in it.
That's good. That's good. So it could be that the opportunities on the market put you in a position, Carly says, where you feel like you'd rather take this bet, you'd rather play at the casino with these companies and not with others because this is all you have. That's a good intuition. But I think there's a reason that's more related directly to the material we studied in class. If you go back to the role, let me give a hint, the role of the underwriter, does anyone have a story whereby the role of the underwriter might explain why and sometimes we see greater overpayment than underpayment? Does anyone have a story? Yes, in the back. I don't think I've checked you. Tell me your name. Carolyn. Oh, I have checked you, Carolyn. Yes, I'm sorry. Go ahead. Well, that's certainly the case, that when it's overpriced, just so everyone gets it, who wins when the IPO is overpriced? Who wins? Who gets the underwriter, right? Or the first buyers, the underwriter's friends, whoever. It's the same sort of group. Everyone sees that. Nod your heads if that's clear. Okay? They are, after all, the ones who are able to sell into the secondary market, into the subsequent buyers, at an inflated price, and then it starts to decline. Right? So whoever bought early, it doesn't really matter which party, whoever bought early did well. So Carolyn's right to say, look, that group did well. But remember, there's always a chain of buyers. And it's like, usually, so I guess there's a couple possibilities, right? So one story is that you're able to trick the next buyer more right now or in the last few years. So the underwriters are really good at kind of hyping up the offering, but that's not enough. It's also got to be that the next buyer in the chain is really bad at detecting the BS. Okay, so that could be, and I think both Caroline and Carly are picking up on one story. Are we, okay, good. Just keep going, no problem. I think Caroline and Carly are both picking up the story that there could be optimism in the market that asymmetrically affects buyers more than sellers. Kind of everyone is willing to overpay. Now, one problem with that you'll see in the article is that the market as a whole over this window was not declining, was not overpriced. So if you had bought non-IPOs over the same window, you would have made money. They were underpriced. So it's tricky to pin the story on general market sentiment that buyers are just willing to overpay, where so savvy underwriters can kind of sell into optimism systematically. So why it's useful to understand the institutional details of Section 5, why it's useful to kind of dig in to Section 5, is because you can ground this economic analysis with something more than just a general statement like the sentiment of the market. Part of why I'm trying to help you see both the economic rationales and the law is because there's often a really interesting interaction between the two. So one story might be closer to the rules we have in place to try and prevent underwriters from systematically overhyping offerings, right? So there's something about Reg A+, about the details of those rules, and we're not going to get into it today, but you can be thinking about it, and when we get to Reg A+, maybe we'll resume this conversation and talk at a more specific level. But there's got to be something about Reg A+, and the rules that it relaxes at that level of specificity, right? At that level of concreteness where you can say, yeah, it might be, for example, that the roadshow is gone. And there's no roadshow. And because there's no roadshow, there's something about the roadshow that helps you as a buyer form the price. It might have something to do with the informed trading advantages that are given to participants at a roadshow. That those informed trading advantages are actually key to preventing overpricing in the short run. Whatever the answer is at that resolution, okay? Nod your heads if you see this. It's not a general story about the market. It's a story about something about securities law that isn't functioning like it should at certain points in time. And that could very well be related to general market sentiment, to the fact that we are in a relatively strong economic expansion over those years. But that's not enough because the market as a whole was not overpriced at the same time. You've got to identify something. So we'll come back to it. I think it's worth thinking about. I don't think there's a magic bullet answer, right? People probably will write about this. You might even write a note about it. But you want to be thinking about what it is about Reg A+ when we get there that actually changes the tendency of buyers to overpay. That's an example of how you connect the theory to a specific setting. You talk not only about the general rule, the general idea that idiosyncratic risk shouldn't matter because you should be just as likely to overpay as underpay, but you're able to connect overpayment to something in the law and make a convincing argument about how that legal institution, in fact, furthers the sort of systematic overpayment. And if you read the Wall Street Journal article, what's interesting is that they really don't know. They have no idea. They basically conclude that there are a lot of firms out there that shouldn't be IPOing, and it's kind of really weird that underwriters are setting prices so high for these companies. And that should be a clue to you that it's a puzzle, right? And it's a puzzle that may have something to do with the way securities law curbs incentives at different points along the path. Okay? So we'll come back to that when we study Reg A+. Questions, though, on the framework. I want to make sure the framework is clear. Yes? Tell me your name.
Ben.
Ben.
Sorry, this may not be technically on the framework, but isn't there a sense, like just a common sense issue, that if someone was, if a firm was using Reg A+ to sort of benefit from reduced disclosure or not having to meet Section 5 requirements, that that's a negative signal for that firm, that this is because they don't want to do that type of thing, they don't want the public necessarily to know, et cetera, et cetera?
Right. So that should bid prices down, that effect, right? So on average, if you're an investor and you see a Reg A+ offering for $10 a share, for the reason you just articulated, you should only be willing to pay $9. So it makes it even more of a puzzle. I mean, for some reason, they found buyers at prices that don't make sense, not only because the fundamentals of the companies seem very questionable, but for the reason that you just identified, which is that, if anything, Reg A+ offerings should trade for far less than we even think they're worth. And if anything, IPOs, which were also up at a time over the same window on average, IPOs in general should be worse performing relative to Reg A+. Does everyone see why? For exactly this reason, because even though you can say on average, the average value of a Reg A+ offering, in this example, let's say it's $10, well, just because I gotta wonder why you're using Reg A+, I'm only gonna pay 8 or 9, which creates an automatic return right there of 10 or 20% or whatever it is. So the overpayment puzzle is a really tricky one, right? It suggests a kind of systematic deviation from rationality, almost, from rational pricing. But I don't think it's enough to just answer it by saying, yeah, it's weird, which is what the journal does, right? You want to try to drill in and understand what's different about Reg A+. Right? What is it? What is Reg A+ doing? Davia, is that a question? No. Yes.
This is really hard to follow in parts. So I understand you were like saying that the young lady's response is like very good, right?
Yeah.
So are you saying that we're observing, like, perhaps we're observing lower prices in this particular offering because we're cutting out the waiting period? Is that correct?
Well, we're observing higher prices at upfront, right? Yeah, it could be. We don't know. So it's certainly true that cutting out the waiting period, as Carly said, could, in fact, reduce the opportunity for you to figure out which is a good or bad investment. But the problem is it doesn't explain at least two fact characteristics of this story. One is it doesn't explain why that doesn't cancel out on average. So you might be getting it right, you might be getting it wrong, but why are you overpaying on average when you're getting it wrong? Because the kinds of firms that you're missing out on, because you don't have a quiet period, may be just as likely. Is this the computer working? Oh, perfect. I'm just going to use the computer. Yeah, thank you so much. Thank you. Great, AV is back. Thank you. So the kind of firms that you might be overpaying for could very well be that there are plenty out there that you're also underpaying for. So you might miss out on, an overpriced, terrible firm, like the ones in the article, right? But you also might miss out on the next Facebook. And why is it that in the data we see that you overpay more than you underpay? Nod your heads if this is clear. Okay? Why is it that you overpay more than you underpay? Well, one reason might be that there's something about this time that makes investors, buyers, willing to pay more than they should. But why that's particularly perplexing is that, after all, Reg A+ is a bad signal at some level. I mean, if anything, it suggests maybe you have something to hide, or maybe you don't want the extra scrutiny that comes with a regular IPO. So if anything, as a buyer, you should be willing to pay less. Is this crystal clear? David, do you see this now? Is this clear? If anything, because you see a buyer using an exemption, because you see a firm using an exemption like Reg A+, as a buyer, you should think, well, they're probably worse than any other IPO on average. And if they're worse on any other IPO on average, I should be willing to pay less. And if I'm willing to pay less, then I should be making more on a percentage basis on my investment. Is that part clear? Nod your heads if you see that. Big nods. Yes. About maybe 70% of you. Say it one more time. I want to make sure we all see this logic. This is the kind of logic you need to know for this class, okay? You're evaluating Reg A+. I'll say this one more time. You're evaluating Reg A+, and you think, this is interesting. The Wall Street Journal reports that most Reg A+ IPOs are trading today at prices far below their IPO price. That's the Wall Street Journal article. How could that be? Well, Reg A+ shortens. It doesn't really matter what it does exactly for this conversation. It makes it easier to IPO, faster, cuts out the quiet period maybe, does stuff we're going to learn. It doesn't matter. How could that make it more likely that you'll overpay than underpay for an IPO? Because that's what the data show. How could that be? So Carly says, look, it could be that by cutting out things like the quiet period or by shortening or accelerating the process, you have less of an opportunity to evaluate the risks of the investment and get a better sense for what this company is worth. But why does that make you more likely to overpay? Because sometimes you'll miss out on great deals too. And there's no reason why less time should cause you to miss out on great deals too. We said this yesterday, right? What's the logic? The logic is if I have less time, I'm going to jump and be the first one to buy. That means sometimes I'm going to buy crap, for lack of a better word, and sometimes I'm going to buy gold. But why would I be more likely to... Is this clear? Hang on, let me just finish the logic. So then we said, look, in order to explain why you might systematically be overpaying, you got to point to something about this moment in time that seems to be unusual. Because it's got to be a kind of, as we said earlier, sort of macro story. It's got to be a systematic story. It can't just be canceling out. Because if it canceled out at every moment in time, go back to our chart. Remember our chart of IPO returns. If all the time you're overpaying, underpaying, you would always be making the average. You see this, right? If you were always overpaying, underpaying, and it was instantaneous virtually, you'd be making the average every time. Like every day, you'd be making the average. Every day I buy an IPO, I buy 10 IPOs. 5 of them are too expensive, 5 of them are too cheap. On average, I make the average return on an IPO, whatever it is. You see this, right? Hang on one second. Let me just finish this. So it's got to be that I'm at a particular point when I'm overpaying. What could be the story? So Caroline and Carly both hinted that it could be something about the time that we're in. It could be something about the structure of Section 5. We haven't answered what exactly it is. But there's got to be a story about why Reg A+ causes you to overpay. And Ben said, look, one reason this is especially puzzling is that if anything, you should be willing to pay a lot less for a Reg A+ offering. You should be willing to pay like less than you would for any other IPO. And so if anything, because you're willing to pay less, your percentage gains should be higher. If you pay $5 for a firm that's worth 10, on average you'll make 100%. You'll double your money when it goes from 5 to 10. Everyone sees this now, right? Nod your heads if this is clear. Okay. Now, questions. Michael.
Could it just be the fact that since Reg A+ is new, people didn't know the appropriate discount to discount the initial offering prices, and so it was just the market failure determining what the discount should be?
So one story is it's just, we just not enough time has passed. So it's 3 years, 4 years. Now it's just they should be applying us. I forget the numbers in the article. We can pull it up now, but it's something on the order of, I think it's like 30 or 40% declines, maybe more. So like a massive discount, right? Yeah. I mean, I'm kind of skeptical. Like if I'm sort of with Ben on this. Like if a company is going on and taking advantage of some exemption, I don't know. I would be skeptical. I would bid down. Maybe I'm not skeptical enough, right? Right, exactly. Yeah, so that could be. That's just a transitory, out of equilibrium story. Yes. Maya? No. Maya, yes.
So I know yesterday we talked about Section 5 reduces volatility.
Yeah.
Cuts off kind of really good, cuts off really bad.
Yeah.
In the middle. So maybe by kind of jumping back on, even though that window time is the Reg A plus, maybe what you're doing is, I think maybe what we're seeing are people who aren't as afraid of these kinds of risks and kind of want the bigger returns you can have in your
Sure. But if I agree with you, Maya, absolutely. These are risk-loving investors who buy A+. So Maya says, look, the folks who are buying Reg A plus offerings are the ones who like more risk. But where's the return? Right? Like, where's the wins that offset the losses? I mean, there was one, the coin, right? The company that bought a crypto asset. Who knows how much that's actually worth. But, there was one case where the offering price was above the, yes. Do I have you here?
Arthur?
Arthur.
Arthur,
there you are. Yeah.
Is it possible you're just looking at a different base of investors? They're raising relatively small amounts of money. Like, you don't need institutional investors to raise 50, 30 million. Like the one example is the chicken noodle soup one. That's like Ashton.
Right.
That's Ashton Kutcher's company. They raised 30 million. He's probably got 10,000 fans that have $3,000. They'll invest in him
Right.
without thinking.
Yeah. So these are just like, this is kind of like Michael's critique, but it's a little bit different flavor, which is like, this is all dumb money. Basically, like, these are all just stupid retail investors who are just piling onto crap. As evidence of the plausibility of that story, let's just see what one of these looks like. And for those of you who've seen this, don't give it away. Subscription to the Wall Street Journal is highly recommended. Let's see if I can remember my password. All right. So that's Scott Disick. Does everyone know Keeping Up with the Kardashians? Nobody here watches that. All right. So here you go. This is the best empirical evidence of the plausibility of this explanation. Come on. Mania TV IPO. Live large and own the next MTV with me. Less than $1 per share. Plus all access celeb passes. Limited to 2,000 VIP fans. No risk, no reward. Sounds like he went to our class. Get in now. Buy now. Callers are standing by. It's okay. Let's check it out. The media could not be played. Did they take him down already? No. It worked this morning. Welcome to the Mania TV stock offering. Video cannot. The SEC has already cracked out. Look at that. All right. So there you go. So that's great. So it's a behavioral story, right? So in which case, if this is true, Reg A plus should be trashed and thrown out the window tomorrow, right? I mean, it's just facilitating, like, ripping people off. Yes, Elliot, right? Yeah.
Could decrease transaction costs for underwriters, kind of increase the competition for underwriters, and that way reduce the profits to inform trading and disincentivize them from pricing the IPO correctly, and maybe that could have something to do with
Wait, say that. That's interesting. Say that again. So there's less competition.
for underwriters. There's less competition. I mean, there's increased competition for underwriters, which is going to reduce the fees and then disincentivize them from pricing the IPO correctly.
Yeah, okay, good. Good. Elliot's got a good intuition here. So Elliot says, look, maybe what it is that it's not Mania TV, MTV of 2018. It's actually potentially very legitimate businesses. I mean, after all, there are law firms behind these and so forth. It's not complete nonsense. And maybe the problem is that the valuations are really hard to pin down. Because the valuations are hard to pin down, they're costly to pin down. We need a greater profit for informed traders. Remember, we talked about the listening problem, that it's costly for you to expend resources sometimes to figure it out what the firm is worth. And so this might be an example of where disclosure falls short. Now, that's actually a great lead into our materiality conversation, which is what we're supposed to be spending the day on instead of Mania TV. But there's a good intuition there. I think one problem, again, that might mean that underwriters don't get it right. I'm not sure it explains Ben's point about why you wouldn't just bid it down if you're the buyer. So if you don't have information and you think that the reason why you don't have information is because these could be worse on average, then you should be bidding down the price to reflect your lack of information, which is another way of saying the effective bid-ask spread should be very wide. And the data would not suggest that that's the case, but it could be some combination of these two. So it could be that the exuberance explains why you have buyers, the excess competition on the underwriting side explains why underwriters aren't getting it right for their own institutional reasons. Those two kind of come together and form a perfect storm. Great analysis, right? And the kind of thing that would get you a lot of points on the exam. Okay? If it's all right, Ophir, let's move forward, just because we were supposed to do Texas Gulf today, and it's already 11:20. Let's talk about materiality. So we left off yesterday going through this treasure hunt of, we'll have to do filed versus furnished tomorrow, because so we'll come back to that fun. But we went through Form 8K, we went through the 10K, Reg SK, we went through all of these mind-numbing, rules, and in the end we said it really all comes down to what's material. Now, can someone who read Franchard tell me what happened in Franchard? Now, I've been now told by my senior faculty colleagues that I'm way too easy on you, that I'm not cold calling, and so prove me right here for being kind. And someone volunteer. Yes, Gregory?
Yes.
Yes.
So Glickman is a real estate developer, and he basically sets up Glickman Corporation to sort of organize all of his different limited partnerships and corporations under one control. And he does two things in particular that he was not fully disclosing in his different prospectuses. One was he was advancing money to himself in much greater sums than he had disclosed in the 1960 prospectus, and then he also was pledging his blocks of his stock, and that was not disclosed at all.
Great. Perfect. Gregory points out that Glickman here, our owner, kind of treated the corporation as like a personal bank account, right? Could anyone figure out why he wasn't criminally charged with embezzlement or theft? Michael?
Then you pay it back.
Yeah, but that doesn't get you. It's true, but it doesn't get you off the hook, because if you have criminal intent, right? You can repay your victim, but if you but maybe that was relevant to the intent issue, right? So maybe the fact that he was willing to pay it back, I guess we could jump back forward in time and then say he didn't. I couldn't figure it out. I think maybe it had something to do with, there's this reference to their own administrative problems that they, somewhere around here, it says that they were not running the company very well. They, as in the other directors, and the treasurer, that was the other reason maybe. The treasurer was in on the deal. So if the treasurer, it says Bernard Mann, who was registrants as well as Venata, the company that Glickman was transferring money to. He was a treasurer for both of them. He had known of the withdrawals and collaborated with Glickman. So maybe that's kind of what took the intent off, and then after all, if he paid it back, we say, well, that's enough, right? It's kind of interesting. Certainly the civil liability is foreclosed with the repayment, right? Because that's a damage-based remedy. So yeah, so maybe this doesn't look very, very criminal. So what's the question, right? So the question is, so Gregory, I'll stick with you one more minute here, which is sort of what was Glickman's claim, or effectively the defense claim regarding the adequacy of the disclosure, and what was the argument that the court rejected in the little excerpt we have?
Well, I think their argument is that the disclosure, that this really wasn't so significant. They had dealt with it internally. He was in the process of paying it back, and because of that, it really wasn't necessary to, they shouldn't be stopped from trading because of this previous problem.
Right, that's right. But let's look at page 140 in the casebook with paragraph that begins with respect to disclosure of pledged shares, which is an excerpt from the opinion. With respect to disclosure of the pledged shares, so he had pledged shares as collateral. And he says, look, registrant is not aided, that's the company that's the subject of the order here, is not aided by pointing out that our registration forms under the Securities Act, which we looked at some of them yesterday, and the reports required under the Securities Exchange Act, which we also looked at yesterday, right, do not call for disclosure of encumbrances on a controlling stockholder's shares. So the court is acknowledging that the rules that we looked at, those items, did not include the disclosure of encumbrances, like what is an encumbrance? Well, you had pledged the shares as collateral, so that means that you couldn't actually sell those shares because there was a security interest, right, on the shares. This is all, nod your heads if this should be first-year stuff, right? Maybe, okay. So pledged the shares as collateral, you got in a loan, you pledged the shares. The shares then can't be sold because they're serving as collateral. That means there's a security interest, like you pledge a house for a mortgage loan, right? The house is collateral. You can't sell the house without repaying the loan. But he argues the reports required under the Securities Exchange Act, that Form 8K that we looked at together, does not require disclosure of encumbrances. So isn't that enough? I mean, we said that there isn't a general rule of material disclosure, but rather that you have to comply with the exact wording of Form 8K, Reg SK, the 10K, and so forth, which in this setting are all incorporating Reg SK, the item numbers in Reg SK. To me, that's a pretty powerful argument. Now, what does the court say? So we'll just keep reading the paragraph. The fact that such disclosures are not required of all issuers and their controlling persons in all cases does not neglect their materiality in specific cases. The registration forms promulgated by us are guides, this is the commission, intended to assist registrants in discharging their statutory duty of full disclosure. They are not and cannot possibly be exhaustive enumerations of each and every item material to investors in the particular circumstances relevant to a specific offering. The kaleidoscopic variety of economic life, I love when lawyers do this, precludes any attempt at such an enumeration. It would just be too hard to list the things you actually have to tell investors. It's too much of a kaleidoscope. All right. The preparation of a registration statement is not satisfied by a mechanical process of reporting narrowly to the specific items of the applicable registration form. Now, this is weird, right? It's weird because there is no rule or statute requiring the disclosure of any or all material information to shareholders. None. You will not find it. It does not exist. And in fact, the court doesn't say that there is. What's the basis for this conclusion? Gregory, do you have it in front of you?
Well, Rule 408.
Which says?
Which says, in addition to the
Great. Perfect. So there's an affirmative duty to do just what Rule 408 says. You shall add further material information as may be necessary. What? To make this required statements. What are the required statements? The things required, right? The required statements did not include the disclosure of encumbrances on a controlling shareholder's shares. So the only way, technically, formally, correctly, that you reach the conclusion that these, turning this one off. There we go. The only way you reach the conclusion that these particular items must have been disclosed, these encumbrances on the controlling shareholder shares, is if that additional detail is necessary to make other required statements not misleading in light of the circumstances in which they were made. Now, this is a bedrock principle of the securities laws, but notice that it basically means nothing. Like, if you follow Franchard, I mean, it's really broad, the interpretation of Rule 408 that Franchard is taking. Because the court articulates no limiting principle here to when it might not be, like, material, it might not be required to be disclosed because it wasn't listed. Like, when does that rule apply? When does required statements actually mean required statements? Like, so Franchard leaves us wondering this. What's great about Franchard is that in the following section, you see this when the commission looks at the issue around whether the directors had to disclose their own lack of oversight. It says, if you look on page 191 of the casebook, in the middle of the paragraph beginning in our view, well, I'll just read from the beginning. In our view, the application of these standards on a routine basis is referring to the standards of a director's responsibility for care of the business, to take care when overseeing the firm. The application of these standards on a routine basis in the processing of registration statements would be basically incompatible, of course, right? It's so self-evident that would be incompatible with the philosophy and administration of the disclosure requirements of the Securities Act. Of course, outright fraud or reckless indifference by directors might be readily identifiable and universally condemned, but activities short of that, which may give rise to legal restraints and liabilities, invoke significant uncertainty. To generally require information in Securities Act prospectuses as to whether directors have performed their duties in accordance with the standards of responsibility required of them under state law would stretch disclosure beyond the limitations contemplated by the statutory scheme and necessitated by considerations of administrative practicality. This would require evaluation of the entire conduct, In our view, this is a function which the disclosure requirements of the Securities Act cannot effectively discharge. It would either result in self-serving generalities of little value to investors or grave uncertainties on the part of those who must enforce and comply with the Act. So this is a real puzzle, right? I mean, you got to look beyond the enumerated items to deduce that encumbrances on a controlling shareholder shares, that the fact that a controlling shareholder had pledged his or her shares as collateral, that is, of course, so obviously something shareholders would want to know. But the fact that directors aren't discharging their duties of care under state law, would just, the idea that we disclose it would be contrary to the philosophy of the security. I mean, this is typical formalism of that era. What is this, like the 1960s? It basically lacks any logic, right? It's sort of, we're just going to ex post rationalize. We're going to say, of course, it was so self-evident that you reached this conclusion. That's why we're writing it, because any reasonable person would reach this conclusion. Yes?
I just have a question, though.
Caitlin? Yeah. Yeah.
If we're just considering directors' general duty of care, typically a court would view that under the business judgment rule and it's accorded a fair amount of deference.
Yes.
Even insofar as they would have to disclose something that's very specific, I'm not even sure a court would wade into that. They would probably say,
Yeah. Yeah, so Caitlin makes a great point. Shows she's taken and done well in corporations, which is that the business judgment rule applies to violations of the duty of care. And Caitlin is right. Have you taken corporation? Yeah, I figured. All right, good. So Caitlin pulls in a nice. I'm gonna reach to Delaware law or just state corporate law, and isn't this can't Franchard be rationalized under that view? Well, what is the issue in Franchard? Franchard is not a suit alleging a violation of the director's duty of care. Franchard is a suit alleging, not a suit, it's an enforcement action by the SEC examining whether the board of Glickman had to disclose its utter negligence that we might all agree would not give rise to liability under the BJR, under the business judgment rule. But where the rubber meets the road, I think, is the way you articulated the encumbrances, might be very relevant to the value of Glickman's firm, right? So the question, and I think you're right to say that we should look at value. So Caitlin says, look, encumbrances clearly affect the value of the firm. But the fact that you let the guy just basically write checks out of the business account for a long period of time to fund his other enterprise definitely matters for the value of the firm. Now, it may not give rise to liability, like you couldn't bring a shareholder class action suit against the board for violation of its duty of care, let's say. That's a corporate law question. But you're right, Caitlin, to frame the issue as whether or not that would matter to the value of the firm. And I think, I mean, tell me, do you disagree? That would be very value relevant. Because it's the fact that the board failed to supervise that not only led to the current financial situation of the firm, but tells you something about its future, about the future oversight that the board will conduct. I mean, if they did such a bad job in the past, you've got to wonder what that tells you about the board going forward. And if you were an investor at the time and had learned that they discovered what Glickman did and that they weren't supervising and they didn't have good internal controls, I think you'd want to sell your stock at that point, because it wouldn't just be baked in to whatever financial loss the firm had, which might be in your category of very concrete facts. You know, okay, you disclose the financial loss. But the fact of the board's insufficient supervision in and of itself is, I would say, value relevant to your decision as an investor going forward, right? So I think you're right that the business judgment rule correctly precludes liability for the failure to oversee the firm. But I actually think the rationale you're using to apply, to bring in the encumbrances would similarly work with the board's duty of care, right? That there are violations of the duty of care that rise to a level that are value relevant for shareholders. Now, you might ask, are all violations of the board's duty of care at that level? And that might be where we could take that framework that you're giving us, Caitlin, and say, look, maybe some routine or ordinary don't reach that level. Some routine or ordinary violations of a board's fiduciary duties don't reach the level of being sufficiently value relevant to require disclosure. But does everyone see that that's the issue? This value relevancy is going to be the prism through which Texas Gulf looks at the question of materiality. But it's a tricky prism. It's a really tough one. All right, so we're going to go through it the rest of the class today, and we'll spend a considerable amount of class time tomorrow on it. We want to make sure you see this. Yes, Magdalena. The commission, yeah. Yes.
One is integrity of the director, and then in this specific case, it was personal benefit because he was taking the money out of the company for his personal
Yes.
obligations, right?
Yes.
I think this personal benefit could be an important element whereas when looking at this duty of care of directors, they would not be doing that for
That's a good point. So Magdalena says, look, kind of like the duty of loyalty, and this is also, so you're strengthening Caitlin's objection, which is, look, the duty of loyalty, the difference between a duty of care and duty of loyalty violation, for those who know corporate law or taking it now, is that duty of loyalty violations tend to involve some kind of self-dealing. This was clearly a case of self-dealing. Isn't that a rationale? Well, yeah, and these facts, you could probably get there, right? You could probably rationalize Franchard on those grounds. It wasn't the grounds that the SEC actually used, but it could, ex post, rationalize these facts, I think. But notice that doesn't really go very far, right? It doesn't take us very far. Because at the end of the day, as an investor, you want to know, like, whatever materiality means, it's got to mean more than just self-dealing transactions. Right? It's got to mean something about the value of the firm that goes that's much broader than just whether or not you violated a duty of loyalty and could be liable in a shareholder litigation setting. Right? So we got to have something more. So yeah, does everyone, any more questions on Franchard? So Texas Gulf kind of teases this out. You can see how Franchard tees up Texas Gulf nicely, because the two holdings in Franchard with Glickman's and versus the director are just, they kind of leave you with no guidance as to what materiality actually means, other than the court kind of saying in this setting it rose to that level, but in another setting it may not, and you don't really know. In between, I believe it was in between Franchard and Texas Gulf. I'd have to check the dates again. We had the Katie Roberts case. So Katie Roberts, which I'll just mention briefly, was a case that involved a broker-dealer, and there was an individual sitting in the room who heard about a dividend that a corporation was going to issue, ran out and bought the company, clearly was found liable for insider trading. Like I said yesterday, we're not doing insider trading, so we're going to unpack these cases when we get there. But by the time Texas Gulf Sulfur comes up, there are some precedents. And Texas Gulf Sulfur, just so everyone is clear, is a Second Circuit appellate decision. Okay, Franchard is an SEC administrative rule, and I'm not remembering whether Katie Roberts was I believe that was just an administrative decision. But the procedural posture of Texas Gulf is much broader, right? Now we're essentially setting law here for the entire Second Circuit. And as a result, the stakes are much higher. And what you read in this opinion is the court struggling with very little precedent as to what materiality actually means. So who will volunteer the facts of Texas Gulf to kind of tee us up with understanding how these issues came to bear in the context of Texas Gulf? Who will be brave enough to set out the timeline of Texas Gulf? Who would like to do it? Abir, yes? Go for it.
Texas Gulf was exploring some land in Canada in 1957 and came upon what it thought could be a good prospective mining area. And I think in 1959 they sent some material I think the word they used was to assay it in the U.S. By 1963, November 1963, they got some great results back. And then from 63 to 64, some insiders bought stock and some warrants. By 12th of April, some people got wind of it, and the New York Times published an article saying that there could be this great mining discovery in Canada. 3 days later, the insiders released a press statement dampening expectation. Also at this time, they wanted to keep the discovery on the down low because they were indulging in a land acquisition program. So they didn't want to, I guess, raise the price of land so they could buy it at a low price.
Yep. Exactly.
And then 3 days later, just before the press statement, before they released another press release, stating that there actually has been a discovery. Some insiders made some, they filed to buy some stock,
Yep.
further stock, and some people also bought some options.
Yep. Perfect. And then what?
And then they were all found
Yeah.
liable.
So after the press release, it was, the last part of the facts was just the stock price. By May 15th, so April 16th was the day of the announcement. The stock was trading at 36. Well, it closed at 36. This is on right at the very end of the recitation of the facts. By May 15th, 1 month later, the stock was selling at 58.25. So it was really high. And if you had bought around that time, you did very nicely, especially if you had bought earlier. When a lot of the insiders did in November, when it was trading around 16, 17, 18. So you did really well if you were buying in November. Okay, perfect. Exactly right. Excellent. So the issue in Texas Gulf is whether that trading constituted insider trading. Well, there's two issues, actually. One is a violation of 10b-5, which we're going to learn. And the other is a violation of Section 10 in another way, which we're going to get to, whether the press release in and of itself by the company was deceptive. Don't worry about that. Like I said yesterday, we're going to get there. But the focus of our conversation today and tomorrow is what exactly is material inside information. The question that we're interested in is whether or not what was not disclosed in Texas Gulf constituted material information that either should have been disclosed or should have precluded trading on the basis of it. So we're going to focus today and tomorrow on what is materiality. Guided by Franchert, which gives us no guidance practically, and guided by this Katie Roberts case, which was an extreme obvious case of running out and buying on a dividend, we're going to try to grapple with a setting in where it's really not clear what information is material and what information isn't. So, Abir, I'll stick with you for a minute or two more. So what is the majority kind of focus on in its discussion of why the information that the insiders held was material? There's a couple points that the majority kind of narrows in on. Do you remember?
Well, I think the evidentiary basis was the fact that the insiders purchased stock themselves while disclaiming it, and I think they used something called a probability magnitude test.
Yeah, that's right. Yeah. So where is that probability magnitude test? So, let's see. So page 848, right, of the opinion, there's a section beginning B, material inside information. And here the court helpfully starts out by pointing out that an insider is not always foreclosed from investing in his own company merely because he may be more familiar with company operations than are outside investors. So you can buy shares in your own firm or sell them if you are an insider. Like, there's no categorical prohibition on it. However, in citing a law review article, the Second Circuit concludes that an insider's duty to disclose or abstain, that's the rule of insider trading we're going to learn, arises only in those situations which are essentially extraordinary in nature and are reasonably certain to have a substantial effect on the market price of the security if the extraordinary situation is disclosed. Now, you would think that the citation to a law review article means that actually has some, like, predictive content, that like analytical content, that you can like actually use that test. But when you read Fleischer's article, great article, but it tells you nothing about when a situation is actually essentially extraordinary. And this is the problem with the law in this area. So it has to be essentially extraordinary, and it has to be reasonably certain to have a substantial effect on the market price of the security. Go figure, right? I mean, what? All right, so we got to try to get some better guidance here. So then they go on and say, nor is an insider obligated to confer upon outside investors the benefit of his superior financial or other expert analysis by disclosing his educated guesses or predictions. The only regulatory objective is that access to material information be enjoyed equally. Put a question mark there, because we just learned a few examples of when that's not the case, but all right. But this objective requires nothing more than the disclosure of basic facts. Basic facts. What's a basic fact? I don't know. So that outsiders may draw upon their own evaluative expertise in reaching their own investment decisions with knowledge equal to that of the insiders. With knowledge equal to that of the insiders. Okay. And then the Second Circuit goes on to say, well, furthermore, now maybe they get a little bit more specific. They say, let's not worry about this idea that the trial court had that Section 10 insider trading cases, because they're brought on the basis of hindsight, we should be conservative with our construction of materiality. No, no, no. The basic test of materiality, the court says, is whether a reasonable person would attach importance in determining his or her choice of action in the transaction in question. This, of course, encompasses any fact which is reasonable and an objective contemplation might affect the value of the corporation's stock. Now, there's at least 3 different standards that have been thrown out so far, if you've been paying attention, right? I mean, there's basic facts. There's essentially extraordinary in nature situations which are reasonably certain to have a substantial effect. And then there's whether a reasonable man would attach importance, any fact which is reasonable, which upon reasonable and objective contemplation might affect. It's just a mess, right? Like, there's nothing here to guide you other than a lot of gobbledygook. But then, towards the end of the paragraph, what do they say? Material facts include not only information disclosing the earnings and distributions of the company, but also those facts which affect the probable future of the company and those which may affect the desire of investors to buy, sell, or hold the company's securities. And here we come to Abir's point, which is that the court now tries to make sense of it all. Whether facts are material within Rule 10b-5, when the facts relate to a particular event and are undisclosed, will depend at any given time upon a balancing of both the indicated probability that the event will occur and the anticipated magnitude of the event in light of the totality of the company's activity. So that's this test around probability and magnitude. Still doesn't quite tell us when you cross the line, but at least it gives us like a checklist to work with, rather than a phrase like basic facts or upon deliberative, objective contemplation. I don't know what that means, but at least we got a test we can work with. Okay. So Abir, the majority and the dissent disagree about the application of this test, right? They both agree essentially. The dissent kind of uses different terminology, but it all comes down. What was the factual disagreement between the majority and the dissent when applying this test to Texas Gulf?
First, I think there was some disagreement over whether the results of the rock amounted to was evidence that the discovery would be of a magnitude that would make it material.
Yeah. So what was the factual record on that point? And if anyone knows, you don't have to. Go ahead if you have the answer. If not, we can. Okay. Does anyone remember? Like we give Abir. He's been great. So anyone else? What was the factual record on the magnitude of the find? What did the dissent? What did the dissent say? What did the majority say? Does anyone remember? I'm seeing like half hands. Like, come on, no? Yes. Amy, gotcha. Yes, that's right. But there was actually expert testimony on this point that the dissent highlights. You're right. So if you remember, the expert testimony was exactly on that question. So on page 872 of the opinion, the dissenting judges, there's two of them, Moore and Lombard, say, look, well, right before, at the end of 871, no more is it for this court to make an independent assay of the evidence or of the core, the mining core. Wanting the knowledge requisite to make our own appraisal of the significance of the core, we must depend upon the experts. A correct decision in this case may well hang upon their testimony and its credibility, because what these observers knew or should have known between November 12, 1963 and April 9, 1964 is basic to a determination of what, if anything, should have been disclosed. For the defendants, what did Dean Forrester say? Dean Forrester. Dean Forrester. What did Dean Forrester say? Alistair. Right. So maybe like this means nothing. What did Dr. Parks say? Alistair. Right. So both of the expert witnesses of the defense that were brought by the defense argued factually, like they testified factually, that in fact the probability magnitude of the find here was not so great. What does the majority say about that? First of all, procedurally, what is the majority? The majority slips, because there's a little bit of a problem, right? Those who've taken civil procedure, I think everyone has, right? You're not supposed to be, what? You're not supposed to be challenging factual determinations unless they're clearly erroneous on appeal, right? So what does the majority have to say about the question of whether that is actually a factual? I'm giving you a hint here. What does the majority have to say about that claim that this is factual? Christian?
I don't remember exactly, but I think the majority said we're not questioning the factual record, but we're discussing the trial court level determination of materiality, so the legal issue of how we interpreted that.
Page 850. Our disagreement with the district judge on the issue does not go to his findings of basic fact, but to his understanding of the legal standard applicable to them. And then, what do? Our survey of the facts below conclusively establishes, gotta love this, right? That knowledge of the results of the discovery hole would have been important to a reasonable investor. Do you love it when judges say it's not a factual issue? It's just legally, totally clear that any reasonable observer would legally view these facts in the following way. Right? Okay, so our survey of the facts found below conclusively establishes that knowledge of the results of the discovery hole would have been important to a reasonable investor and might have affected the price of the stock. Now, what's wrong with that statement anyway? Does it fit the probability magnitude test? I mean, might have affected the price of the stock. I think the dissent would agree with that. That wasn't the issue. The issue was that the chance it would affect the price of the stock was really, really low. And that's what the experts testified. So how can we make sense of the majority opinion on that point? All right, we're almost out of time for today. Here's what we'll do tomorrow. We're going to continue into Texas Gulf, reread Texas Gulf. Think about the following. The majority doesn't even claim that there's any factual evidence ex ante suggesting that, like, shareholders would have attached not just importance but something more than a non-trivial probability to this finding. That's not in the record. So because it's not in the record, and the majority acknowledges that, they point to a bunch of other stuff. So tonight, reread Texas Gulf, and come prepared to talk tomorrow about what the majority does look at. Because what we're going to do tomorrow is think about the way the majority analyzes materiality, and whether that makes any sense, what the implications of that would be economically. Particularly pay close attention to how the majority looks at evidence of trading after the fact. A lot of the majority's reasoning is resting on evidence ex post. So be looking at that tonight. Be prepared to talk about that and how the dissent responds, and what the implications are for embracing ex post evidence when determining materiality. So we're going to do that tomorrow. We're going to link it to the broader tension between informed trading and disclosure and try to understand what contours of materiality are actually useful. There is an event, quick advertisement in room 101, the Legal Tech group is putting on. You're more than welcome to come. It's going to be a panel with some faculty members. I'm moderating, Professor Eric Talley, Katharina Pastor, Kate Judge, if you want to hear about law and technology. Office hours are today at 1:30, from 1:30 to 4. Come by with your questions. Groups are good. I'll see you then, if not tomorrow.